means to make its federation less rigid. Then, my lords, in coming to, my lords, the last paragraph beginning there, in assuaging the rigor of rigidity and legalism, the draft constitution follows the Australian plan on a far more extensive scale than has been done in Australia.
Like the Australian constitution, it has a long list of subjects for concurrent powers of legislation. Under the Australian constitution, concurrent subjects are 39. Under the draft constitution, they are 37. Following the Australian constitution, there are as many as 6 articles in the draft constitution where the provisions are of a temporary duration
and which could be replaced by Parliament at any time by provisions suitable for the constitution. The biggest advance made by the draft constitution over the Australian constitution is in the matter of exclusive powers of legislation vested in Parliament. While the exclusive authority of the Australian Parliament to legislate extends only to about 3 matters, the authority of the Indian Parliament as proposed in the draft constitution will extend to 91. It has then come to 97, 97 being an omnibus residuary clause. In this way, the draft constitution has secured the greatest possible elasticity in its federalism, which is supposed to be rigid by nature. It is not enough to say that the draft constitution follows the Australian constitution or follows it on a more extensive scale. What is to be noted is that it has added new ways of overcoming the rigidity and legalism inherent in federalism, which are special to it and which are not to be found elsewhere. First is the power given to Parliament to legislate on exclusively provincial.
Go ahead. In normal times, I refer to Articles 226, 227 and 229. Under Article 226, Parliament can legislate when a subject becomes a matter of national concern as distinguished from purely provincial concern, though the subject is in the state list, provided a solution is passed by the upper chamber. Resolution must be, my lord. Upper chamber by 2/3 majority in favor of such exercise of the power by the centre. Article 227 gives a similar power to Parliament in a national emergency. Under Article 229, Parliament can exercise the same power if provinces consent to such exercise. Though the last provision also exists in the Australian Constitution, the first two are a special feature of the draft Constitution. The second means adopted to, my lord, Lord, please come to the next page, my lord, PDF 12.
Yes.
Not that the others are not important, my lord, but then to save time, because anyway, your lordships would be going through it. One can therefore safely say that the Indian Federation will not suffer from the faults of rigidity or legalism. Its distinguishing feature is that it is a flexible federation. There is another special feature of the proposed Indian Federation which distinguishes it from other federations. A federation being a dual polity based on divided authority with separate legislative, executive and judicial powers for each of the two polities is bound to produce diversity in laws, in administration and in judicial protection. Up to a certain point, this diversity does not matter.
Just skip that a little bit now and then go to the bottom of that page.
Yes.
The draft constitution has sought to forge means and methods whereby India will have federation.
And at the same time will have uniformity in all basic matters which are essential to maintain the unity of the country.
And then on the next page, Dr. Ambedkar refers to 3 things: a single judiciary,
uniformity in fundamental laws, civil and criminal,
and all India civil service. That's you can then.
Yeah. No, my lord, the rest of it, my lord, but of course, your lordships would be, with the utmost respect, my lord, I would commend that your lordships have
I think we have seen the key of
yes,
the key factors, the key features
correct,
of the constitution which make it federal. At the same time,
yes,
preserve the need for
right,
a certain degree of uniformity.
That's right.
At the national level.
That's right, my lord. No, my lord, immediately, if your lordships cut the chase to the closing remarks, that's the famous, my lord, speech by Dr. Ambedkar.
1949.
Yes.
Where is that?
That is, my lord, at PDF page 1299, same volume. Yes. So I don't think to read that. Would you like to read it? No, sir, you can. You can lay emphasis on. Lord, PDF page 1299. 1299. Starts at 1299. The relevant portion is at 1307.
4160.
Lord?
4160 in red.
Yes, 4160. Well, let's see. The relevant portion is again 1307. Continuous page is 4168.
Can I read it?
Yes.
There's only one point of constitutional import to which I propose to make a reference. A serious complaint is made on the ground that there is too much of centralization and that the states have been reduced to municipalities. It is clear that this view is not only an exaggeration, but is also founded on a misunderstanding of what exactly the Constitution contrives to do. As to the relation between the center and the states, it is necessary to bear in mind the fundamental principle on which it rests. The basic principles of federalism is that the legislative and executive authority is partitioned between the center and the states, not by any law to be made by the center, but by the Constitution itself. This is what Constitution does. The states under our Constitution are in no way dependent upon the center for the legislative or executive authority. The center and the states are co-equal in this matter. It is difficult to see how such a constitution can be called as centralism. It may be that the Constitution assigns to the center too large field for the operation of its legislative and executive authority than is to be found in any other federal constitution. It may be true that the residuary powers are given to the center and not to the states. But these features do not form the essence of federalism. The chief mark of federalism, as I said, lies in the partition of the legislative and executive authority between the center and the units by the Constitution. This is a principle embodied in our Constitution. There can be no mistake about it. It is ever wrong to say that the states have been placed under the center. Center cannot by its own will alter the boundary of the partition, nor can the judiciary, for as has been well said, courts may modify, they cannot replace, they can revise earlier interpretations as new arguments, new points of view are presented, they can shift the dividing line in marginal cases, but there are barriers they cannot pass, definite assignments of power they cannot reallocate, they can give a broadening construction of existing powers, but they cannot assign to one authority powers explicitly granted to another. The first charge of centralization defeating federalism must therefore fail. The second charge is that the center has been given the power to override the state. Then my Lord Dr. Ambedkar says, this charge must be admitted. But before condemning the Constitution for containing such overriding powers, certain considerations must be borne in mind. The first is that these overriding powers do not form the normal feature of the Constitution. Their use and operation are expressly confined to emergencies only. The second consideration is, could we avoid giving overriding powers to the center when an emergency has arisen? Those who do not admit the justification for such overriding powers to the center, even in an emergency, do not seem to have a clear idea of the problem which lies at the root of the matter. The problem is so clearly set out by a writer in that well-known magazine, The Round Table, in its issue of December 1935, that I offer no apology for quoting the following extract from it. Says the writer, political systems are a complex of rights and duties, resting ultimately on the question to whom and to what authority does a citizen owe allegiance. In normal affairs, the question is not present, for the law works smoothly, and a man goes about his business obeying one authority in this set of matters and another authority in that. But in a moment of crisis, a conflict of claims may arise, and it is then apparent that ultimate allegiance cannot be divided. The issue of allegiance cannot be determined in the last resort by a juristic interpretation of statutes. The law must conform to the facts, or so much the worse for the law. When all formalism is stripped away, the bare question is what authority commands the residual loyalty of the citizen? Is it the center of the constitutional state? The solution of this problem depends upon one's answer to this question, which is the crux of the problem. There can be no doubt that in the opinion of the vast majority of the people, the residual loyalty of the citizen in an emergency must be to the center and not to the constituent states, for it is only the center which can work for a common end and for the general interest of the country as a whole. Herein lies the justification for giving to all center certain overriding powers to be used in an emergency. And after all, what is the obligation imposed upon the constituent states with these emergency powers? No more than this, that in an emergency, they should take into consideration alongside their local interests, the opinions and interests of the nation as a whole. Only those who have not understood the problem can complain against it. No, my lord, there is an anguish. Sorry.
Let's see.
Just one paragraph in the next two lines in the next paragraph, my lord. How the in what was the anxiety, my lord, which he shared, and how prophetic, my lord. Sometimes one feels that so prophetic he could have been. Here I could have ended, but my mind is so full of the future of our country that I feel I ought to take this occasion to give expression to some of my reflections thereon. And 26 January 1950, India will be an independent country. What would happen to her independence? Will she maintain her independence or will she lose it again? This is the first thought that comes to my mind. It is not, sorry. Yes, context.
For this also.
Not that, my lord. These lines which start, the point is. Today's context, my lord. The anxiety and the anguish, my lord.
You must complete reading that, Mr. Giri. It's a very interesting passage.
Yes, yes. This is the first thought that comes to my mind. It is not that India was never an independent country. The point is that once she lost the independence she had, will she lose it a second time? It is this thought which makes me most anxious for the future. What perturbs me greatly is the fact that not only India has once before lost her independence, but she lost it by the infidelity and treachery of some of her people. In the invasion of Sindh by Muhammad bin Qasim, the military commanders of Kandahar accepted bribes from the agents of Muhammad bin Qasim and refused to fight on the side of the king. It was Jayachand who invited Muhammad Ghori to invade India and fight against Prithviraj and promised him the help of himself and the Solanki kings. Then, my lords, I'll leave the rest. Next one, will history repeat itself? It is this thought which fills me with anxiety. This anxiety is deepened by the realization of the fact, in addition to our old enemies, in the form of castes and creeds, we are going to have many political parties with diverse and opposing political creeds. Will India place a country above the creed, or will they place creed above the country? I do not know. But this much is certain, that if the parties place creed above country, our independence will be put in jeopardy a second time and probably be lost forever. This eventuality we must all resolutely guard against. We must be determined to defend our independence with the last drop of our blood. No, my lords, these two speeches made by Dr. Babasaheb Ambedkar, two different points of time, one while presenting the draft constitution, the other after the draft constitution concluding remarks. There's not much variance, my lord, except to say that the slanting, my lord, if any, in the distribution of power, lawmaking power, my lord, towards the center was justified by Dr. Ambedkar after the constitution was drafted. My lord, it is after taking into all this that your lordships have also, my lord, over the years, after 1950, interpreted the constitution, interpreted the federal structure of the constitution. My lord, it has been done in many cases, but for the present, my lord, can you just give the paragraph numbers, my lord, and the PDF page numbers of some of the judgments, my lord, starting with State of Rajasthan versus Union of India. Please give the citation.
Just give us the page,
Yeah.
the PDF
Lord, volume 26. Volume 26. My lord, 1977 3 SEC 592.
That's okay. We have just give us the PDF volume now.
Yes.
The PDF
My lord, that is PDF page 54.
At
54.
At para?
At paragraph, my lord, just.
You giving the PDF page of the relevant paragraph or the beginning of the case, whichever way you want to do it. Just give us the page at which the case begins and the page at which you are stressing the extract.
Yes.
PDF 21, PDF 54, my lord, is a relevant paragraph.
All
Three
right.
paragraphs, my lord, from Chief Justice Beck's opinion.
All right. The next.
The next is, my lord, Bommai. Bommai, my lord, is in volume 2. Page 2 onwards.
Page and at page,
My lords, that's what. My lord, there are multiple opinions in Bombay, as your lordships would have.
right, but which are the paragraphs you
My
want?
lords,
Which are
the paragraphs, my lord, can I start with, my lord, in the order in which it is given, my lord,
Sure, no problem.
Justice Pandian's opinion doesn't deal with federalism separately. PDF paragraphs 1 to 9. Therefore, PDF page 2 to 6. Yes. Sorry, PDF page 65, my lord, sorry. PDF page 65, the rest is all, my lord, editorial notes. Paragraphs 1 to 9, and in para 2, he agrees with the conclusions of 1, 2, 4 to 8 of Justice Sawant's opinion, my lord.
All right, then.
Kindly
then-
note that, my lord.
Yes,
My lord, see, PDF 68, Justice Ahmadi's opinion, para 10 onwards.
just Ahmadi.
And the relevant portion, my lord, with regard to the federal character of the constitution is at PDF 69, paragraph 13,
PDF,
69, paragraph 13,
next.
para 23 and 24 at PDF 75.
All right, next.
My lord, but para 247 and 248 PDF 206. My lords, the paragraph, my lord, Ramaswamy, Justice Ramaswamy's opinion, para 247 and 248 at PDF 206.
All right, so we've covered
My
Bombay.
lords, there is a conspectus of the earlier decisions, including Rajasthan and Bombay, in NCT 2,
Yes,
volume 14, PDF 3, paragraph 68 to paragraph 77.
page,
Paragraph 68 to paragraph 77. Just get the PDF page. PDF page. NCT. My lord, I'll give the page number in a moment. Volume 14.
volume,
14. My lord, it doesn't have an SEC citation so far. SEC online is there.
para 68 to.
Para 68 to para 77.
We'll have an SCR citation. I think all of you must now get into the
I
habit
think we
of again citing SCRs. SCR is now digital. We have already got an eSCR. Hopefully in the next few weeks, we'll have a digital SCR. A digital SCR is exactly as it appears in the volume, while the eSCR, of course, is an electronic copy. And we have updated the head notes right up to probably the last month or so now. I'm not sure exact date, but we are pretty much now abreast. So we have a regular authorized reporting of reporter of the Supreme Court. Because SCR had fallen way behind its times, but now it's up to date. And it also has neutral citations as well.
Oh, that's right, my lord, it has neutral citations.
But we are now moving from an eSCR into a digital SCR. So the digital SCR will have a volume.
It always had neutral citations, because it always had. And we were, in fact, used to only citing the SCR. But then, of course, it was not updated for many.
So I would really encourage all of you to just at least skim through the eSCR and
We'll do that.
and if there are any further improvements to be made, please feel free to let me know, because it's a.
ESCR in the first 20 years were head notes.
That's right. That's
They
what
were
I said.
outstanding,
Absolutely.
and that is what is missing. They gave complete picture of the case and what your lordship did.
Now, please have a look at the recent head notes. If there is some improvement, I'll be happy to do it.
My lord, and the corresponding ILRs in the high courts also.
We have revamped our editorial team for the SCR. We have a much broader editorial team. We also have a Center for Research and Planning in the Supreme Court, which is manned by several very talented young people who have been brought in from outside.
Seems that 24 hours are not enough for you.
They're not, Mr. Sibilan. When I leave for home, there's so much to be done every evening after that as well.
Appreciate it.
Some outstanding members of our bar with them, perhaps would
Of course, with pleasure.
likes of Mr. Shankar Narayan cannot, I have no doubt.
But please do have a look at our ESCR, and very shortly we'll have the digital SCR. So if there's any change, any improvement, let me know so that we'll do it.
Well, not strictly on this, but then I'll have to anyway. I thought of referring it in another context on which, my lord, I'll do it in a minute or so.
Also,
But,
the best
my lord,
part, it's a free service. So you can imagine lawyers
Yes.
across the country, from the
Yes.
districts
Yes,
to the high courts, have this
Yes.
free availability of
Yes.
resource material. Law colleges which can't afford to purchase software,
Correct.
they have this free service. It's searchable, absolutely. Yes.
My lord, earlier days I was a reporter for the ILR, my lord, in the High Court. And one good thing was, my lord, it kept one abreast with all the judgments, my lord, which used. But the numbers were not, it was not so numerous then. But then writing the head note always, my lord, was a task. Giving the head note was always a task, kind of. And one had to send it back to the learned judge, my lord, to get his approval also. Because otherwise, my lord, sometimes one misses out the crux of the judgment. Then. My lords, one, my lord, I'll just hand it over, kindly permit me. My lord, when Bomai came out, my lord, Bomai was delivered, Mr. Sorabji, my lord, wrote an article which was published in the SEC. My lord, just give 5 copies. My lord, I am not taking your lordships, but when your lordships have the time, just
Just keep that and put it in the.
Yes. My lord,
Well,
Mr.
just give us
Sorabji argues.
just give us a citation. You don't have to add papers now anymore.
94.3 SEC Journal 1. Just give copies.
1994?
1994 3 SEC Journal 1.
What was Mr. Sorabji's?
My lord, it's relevant, my lord, how Mr. Sorabji argues and persuasively how Justice Sawant's opinion, my lord, should be treated as a majority opinion in Bomai, not on the aspect of federalism. And then my lord says, my lord, this I'll immediately say why it is relevant, my lord, is because it is in Justice Sawant's opinion, my lord, that paragraph 153 comes as a conclusion. And 153.4, my lord, especially, that decisions could be taken, my lord, even irreversible decisions, there is a restriction on irreversible decisions. During the currency of a president's proclamation, till such time as a proclamation, my lord, is approved by both houses of the parliament. That's in para 153.4. I think the learned solicitor has brought your lordship's opinion.
Yes, we saw
notice.
that.
Since the provisions contained, my lord, that is at page 149 of the report. Since the provisions contained in clause 3 of article 356 are intended to be a check on the powers of the president under clause 1 thereof, it will not be permissible for the president to exercise powers under subclause A, B, and C of the latter clause to take irreversible actions till at least both the houses of the parliament have approved of the proclamation. Now, this should be treated, my lord, in my respectful submission, as the opinion of the bench, as a majority opinion of the bench. Lord, I commend this with great respect. I commend this article of Mr. Sorabji for that purpose, my lord. When your lordships, it's in the beginning itself, my lord. It's a page. My lord, on federalism, I'll just make this proposition, my lord, and leave it before your lordships. I've given, my lord, the relevant paragraphs in the judgments, my lord. I have placed Dr. Ambedkar's opening remarks and the closing remarks. My lord, especially in the last judgment of NCT 2, where your lordships, my lord, had a conspectus of the earlier judgments, my lord, which dealt with federalism. There are 2 or 3 features, my lord, which your lordships have outlined. One is that federalism is a basic feature of the constitution. No, my lords, when your lordships have said that, the federalism, my lord, that is revealed, my lord, from the reading of the constitution as a whole. My lord, please keep 370 for a moment aside. Is, my lord, where the distribution of the legislative powers with the parliament and the state legislatures, and with the slanting, my lord, in favor of the state. The reasons have all been given, my lord. I need not repeat it myself because your lordships have articulated it so well, my lord, in the earlier judgments. Now, my lords, whatever it is, your lordships will find that 370 constituted when your lordships have a holistic picture of the constitution and the relationship between the union and all the other states. And then if your lordships looked at 370, my lord, put in an area or carved out an area, my lord, which is not in sync with the general federal features of the constitution for the rest of the country, for the union and the rest of the country. Dr. Dhawan, my lord, pointed out other features, my lord, in part 21, 371 onwards. Point is, my lord, over a period of about 25 years, different provisions were introduced, were inserted in the constitution, giving a certain special provisions, my lord, for some of the states. And all, therefore, an amendment to the constitution and the parliamentary legislation. But point is, my lord, there are 2 or 3 features which emanate out of 370. One is that Parliament requires the consent of the state, the government of the state in relation to matters which are included in list 1 and 3, but not relatable to the instrument of accession. The consent of the state is required for making applicable certain provision, all provisions of the constitution which have been mentioned in clause D.
Just one second. As the consent of the government of the state on list 1 and 3 matters.
Yes.
Which matters do not relate to the IOA.
Yes.
That's right. Yes.
We're not saying.
That is B2.
Yes, B2. D deals with such of the other provisions of the constitution shall apply in relation to that state, subject to such exceptions and modifications as the president may by order specify. And then the second proviso, concurrence of the government is necessary. That it has been done repeatedly, my lord, from 1950 onwards is a historical fact. But the point is, my lord, this sets out the relationship between Union and Jammu and Kashmir at a plane. I'm not saying higher or lower, I'm saying at a plane different from the constantly interworking relationship between the Union and all other states in the country, all other states forming part of the Union. When 370 is abrogated, you have a situation, my lord, which is, my lord, please consider the bifurcation of the state into 2 union territories, my lord, differently. That came about on 31/10/2019. I'm saying, my lord, said when 370 was abrogated by 272, and, my lord, all the provisions of the constitution became instanto eo instanti applicable to the state of Jammu and Kashmir. Jammu and Kashmir, therefore, became a state, my lord, on a complete par with all other states, my lord, in the union insofar as the federal structure is concerned. Even otherwise. My lord, what do the petitioners want? As a solicitor, my lord, it's at pains to point out there is a great deal of expansion of rights, my lord, which could be enforced by the persons who reside in the state. But, my lord, what do the petitioners want? They want the 272 and 273 to be set aside and Article 370 to be resurrected. If 370 is resurrected, we would come back to a stage where there is an oddity
insofar as the federal structure of the constitution is concerned. J and K would continue to be placed, or would once again be placed, on a plane different from all the other states of the union, and the federal working relationship which the constitution behoves us to do will meet with a roadblock one way or the other. Lord, I'm not saying that the one principle of administrative law which your lordships have always applied is, your lordships would not issue a prerogative writ in setting aside any order or setting aside any action taken by the executive. My lord, if such interference by your lordships resurrects, my lord, a situation that was also not completely legal. My lord, paraphrase it. If setting aside 272 and 273 resurrects Article 370, in my respectful submission, if Article 370 is resurrected, that would also be violative of the basic structure of the Constitution. Yes.
This might be a little too far-fetched, because then that would be to postulate that original Article 370 was violative of the
There was a challenge. There was a challenge pending here for several years. 1986, my lord, a batch of writ petitions was then made over to the High Court, whether that's still pending. There are people, my lord, who wanted to prosecute it. But of course, my lord, one of the writ petitions challenging 35A is also, my lord,
It was a part of the original constitution, Mr.
I'm saying, my lord, that the federal structure, my lord, I would only, my lord, let me go by the path of least resistance.
Can't invite us to hold in your favor on an unstateable proposition.
No, I'm saying, my lord, that your lordship, let me take the path of least resistance. My lord, the federal structure which emanates, my lord, from 370 is on a different plane from the federal structure.
Mr. Giri, you are not today confronted with a situation where Article 370 is in the Constitution.
I'm saying, my lord, that if there is a resurrection, then, my lord, there is still, my lord, a cause of action.
35A, etc. is on a different.
I understand, my lord. I'm saying, my lord, these.
I think we better wrap up.
I am wrapping up.
11:25.
My lord, just one aspect on which your lordships wanted an answer, my lord. In Madhav Rao Sidhya, my lord, 1971, 1 SEC 85. Volume 6, PDF 390. Lord, I'll just give the page number, relevant PDF page numbers and paragraphs. My lord, Chief Justice Hidayatullah's opinion, para 65, PDF 443.
What
Para 76, PDF 447.
volume?
My lord, volume 6, my lord, of the case law compilation.
Yes.
Decision starts at PDF page 390.
So what is the proposition you're citing it?
My lord, it's only this, my lord. Your lordship, the solicitor had taken your lordship extensively through Ganpat Rao.
Yes, yes.
Which came about later. My lord, the mandibus was issued in Madhav Rao Sidhya, my lord, where after a serious bit of ratiocination, the lordships came to the conclusion, both Chief Justice Hidayatullah and Justice Shah, that the right which is claimed by the petitioners emanates from Article 291, Constitution, and 362, and not from the covenant. And this is same conclusion was arrived at to hold that 363, which is a bar on the courts, my lord, entertaining such disputes, is not attracted because the right claimed by the petitioners is on a right which is generated and frameworked in the Constitution and not in the covenant. That is why a mandibus is issued. You don't have a parallel here.
1 second. You said that the rights, but Justice Hidayatullah and Justice Shah said that the rights which were claimed by the petitioners originated in Articles 291 and
362.
And not in the covenant.
Not from the covenant.
And what is the next, what is the sequitur that
and therefore, my lords, that 363 was not attracted. 363 has been subsequently repealed, but 363 was not attracted. and therefore a mandamus was issued. Therefore, my lord, the right claimed by the petitioners was under the constitution itself. 291 and 362 were repealed. Earlier, my lord, it was only a question of, my lord, withdrawing the recognition of a ruler under 366(22). That was found to be inadequate because 291 and 362 were still intact. That is why, my lord, in the first matter, in Madhavrao Sindhya's matter, a mandamus was issued. When 291 and 362 were repealed by a constitutional amendment, my lord, no further right survived. There was no privy purse, my lord, which the right to a privy purse which emanated from the constitution or embedded in the constitution. The right was taken away by a constitutional amendment. That's why, my lord, in Ganpat Rao, a challenge to the constitutional amendment on the ground that it violated the basic structure of the constitution was repelled. But petitioners cannot draw any sustenance, my lord, from the ratio of Madhavrao Sindhya is my respectful submission.
Thank you, Mr.
I am deeply obliged to you.
Thank you, Mr. Giri.
Yes.
Are you appearing for?
For a union.
But for the union, how many people will appear, Mr. Nataraj? We don't want to stop you because it's an important matter, but
Yeah, I'll not
way.
repeat anything, and
can you formulate what?
Yes, I'll formulate. I'm cautious of the arguments already advanced on behalf of Union of India, and equally conscious of the time factor which is daring at me through your eyes.
Find you to 10 minutes.
Just I'll only on a different approach which I'd like to give to the entire the facets of this one with regard to the matter. Basically, I formulated 4 issues which I'll cover up in within 10 or 15 minutes. I'll not go beyond that. Article 370 is the only provision in the Constitution which has a self-destruction mechanism. There are other articles which would lapse by a flux of time. That's a different scenario altogether. Number 2, this article did not confer any kind of right. Number 3, continued application of
One.
please, I'm sorry.
Continued application
Of Article 370 discriminated and opposed to basic structure. Fourthly, doctrine of federalism, the foundation which they have laid.
Just wait.
Please. In the stricto sense has no application insofar as Article 370 process is concerned.
What is the 4th one?
The doctrine of federalism, that federal structure principle, has no application in stricto sense insofar as process under Article 370 is concerned. Now, first let me deal with the last point with regard to the federal structure theory which they advanced or propounded in support of their contention. By virtue of it, the Article 370 abrogation and all this process, the federal structure has been violated. While dealing with that, first let me take the sample code 2, the provisions under the Constitution where under the constitutional provisions can be amended. That is Article 368. Now kindly take Article 368 in juxtaposition with Article 370. There are two situations. Under Article 368, that is the provision under which the Constitution can be amended. That is the provision which recognizes, number one, constituent power. Number two, while amending the constitutional provisions, in most of the cases, we require the majority or the 2/3 of the majority as provided under Article 368(1). The second part is equally important, which recognizes federalism, is the next part, where the ratification. Article 368(2) that recognizes federalism in the matter of amendment to the Constitution.
Yes.
Kindly see the keywords under Article 368. Kindly take the keywords under Article 368. (368)(1), notwithstanding anything contained in this Constitution, President may, in exercise of its constituent power, the constituent power is explicitly brought into the constitutional provision for the purpose of amendment under Article 368(1), in exercise of constituent power, amend by way of addition, variation, or repeal any provision of this Constitution in accordance with the procedure laid down in this article. So, for the purpose of repeal, the power exercised is recognized as a constituent power under Article 368(1). Now, kindly go to 2. An amendment of this Constitution may be initiated only by the introduction of a bill for the purpose of either house in a parliament, and when the bill is passed, each house by a majority of total membership of that house, and by a majority of not less than 2/3 of the members of the house are voting. That is the second part. Then proviso, provided that if such amendment seeks to make any change in Articles 54, 55, and so and so, so and so, the amendment shall also require to be ratified by the legislature of not less than 1/2 of the states. So the collective consent theory is introduced under Article 368 for the purpose of amendment of the Constitution. It is a collective consent which is required under Article 368 for the purpose of amending the Constitution. In a way, it is a veto power conferred upon the majority of the states. Now, have 370, Articles 370 in a juxtaposition. Kindly go to Article 373. Notwithstanding anything contained in these provisions of this article, the President may, by notification, declare that this article shall cease to be operative or shall be operative only with such exceptions or modifications as may specify, provided that the recommendation of the Constituent Assembly of the state so and so shall be necessary so and so. 368 speaks of the ratification, a collective consent, and the veto power as a recognition of federal structure is embodied under Article 368. However, when it comes to Article 370, the language is only recommendation, which already they pointed out, it is only
It's been argued consistently.
Please.
The word recommendation has been argued. So many
argued. Therefore, I am not touching. I am pointing out the difference between the ratification as a matter of the federal structure which is brought in for the purpose of amendment, and 370, which only says the recommendation. So,
But equally, the adaptation to the constitution ensured that even in the matter of an amendment,
yes,
the president has to still go through the route of Article 370 bracket 1.
absolutely, absolutely. Therefore, in the stricto sense, Article 368 principles of getting it ratified will not be applicable to when it comes to 370. Only the recommendation is required, which has a very, very limited.
An additional safeguard was introduced.
Correct.
And that safeguard is not merely in matters which require ratification by half the states.
Correct.
But any constitutional amendment has to go through the process of Article 370
370.
in relation to J&K,
J&K.
as it then stood.
Yes, that's right. But however, reading these two articles in a different language will make either of them redundant. Otherwise, straight away we can go under Article 368 for any kind of amendment of the Constitution.
Other amendment provisions will have into different states.
Correct.
It's the provision which only has an impact on
When the larger power under Article 368 itself is conferred for the purpose of certain amendments of the Constitution. When 368 itself is available, there is no question of applying 370. Reading in any other form makes 370 redundant. Or if you apply 370 in any other form, 368 makes redundant.
It's always been put to us that 373 was a self-destructive mechanism so far as 370 is concerned. That we've already noted.
Mr. Nataraj,
Please.
what you're probably trying to highlight
Please.
is that the argument that the federal structure gets affected because of abrogation of 370
Yes.
should not be accepted for the reason
Yes.
that the federal structure is protected by 368
Yes.
itself. And you cannot say that federal
Absolutely.
structure is diluted in case 370.
370 is concerned. So federal structure is applied and protected under Article 368, and under Article 370, there is no such strict application of federal structure for the purpose of Article 370. Any other interpretation would in a way makes either 370 or 368 a redundant provision. No constitutional provision. So therefore, power conferred under Article 370 is a unique, superior power. It is neither a constitutional power, nor a legislative power, nor an executive power. However, it has the flavor of all three. It is a superior power conferred under the Constitution on the President to introduce.
Now look at our problem.
Yes.
Your two ASGs arguing two different things. Mr. Dwivedi said it's a constituent power.
It has the flavor. Yes, it
Of
has.
course, Mr. Dwivedi is not an ASG, but
it-
the point is he's on your side.
Yes.
Now, at some point, we were told that they had differing interpretations.
Yes.
Now we are in a situation where the respondents are coming with
It has the, yes, it has the flavor of all three. It has the flavor of all three.
What I don't understand
Yes.
is, attorney and solicitors are given a perspective of how the constitution is understood from the
Yes.
government perspective.
Yes.
Will we have different perspectives?
No, not at all, not at all, not at all. It is in line with the argument advanced by learned Solicitor General. What we say that it is a unique, extraordinary power conferred on the President to abrogate or to bring in certain changes in the Constitution, which has the flavor of constituent power, which has the flavor of executive power, which has the flavor of legislative power. So that is a plenary power conferred on the President. And when such a power is conferred on the President, plenary power, we need not or we should not treat with any kind of limitations for exercise of such power. Such an extraordinary power conferred on the President need not be or should not be read with any kind of limitations. And it must be given fullest meaning and to be applied without any procedural restrictions.
The proviso has to be forgotten.
Proviso has to be followed. There is no doubt about it. But you can't equate with the Article 368 that the stricter.
If the proviso has to be followed, then what happens to the
No, the-
requirement therein?
No, the requirement is correct, but the yardstick is totally different. We can't equate with the procedure required to be followed under Article 368. Proviso need not be in strict, it need not be followed. And when it's a plenary power, it need not be read with the limitations as held in R versus Burra, which has been applied in the Keshwananda Bharati.
Thank you,
And-
Mr. Naidoo. Thank you very much, Mr. Naidoo. Mr. Jetnani?
Clarification. Whether the power is constitutional power, executive power, or administrative power. But that exercise is irrelevant. It is a sui generis power given only in one article to the highest constitutional. That's not the.
Yes, Mr. Jetnani.
Now I appear for the interveners in 171690.
Could you repeat that, Mr. Jetnani?
But I number 171690 in in the lead petitions, in the lead petitions. I am the intervener. One of my clients.
In 1047.
Yes, in 1037.
1037.
Well, my clients basically are members of the Gujjar Bakarwal community in Jammu and Kashmir. The members of a scheduled tribe. They constitute 73.25% of the total scheduled tribe population of Jammu and Kashmir.
73.25%.
73.25%. Of course, we strongly support the amendments for the reason that the provisions in the Constitution pertaining to scheduled tribes, 330, etc., were never applied.
But Mr. Jetnani, your knowledge is theoretical unless you can state with certainty before us that you have driven around in Ladakh. Have you been?
I've been to Ladakh. I have been to Ladakh. But Manoj, many years ago, many years ago, Manoj, in the days when houseboats used to flourish, in those days, Manoj. And they've come back now.
Houseboats are not there in
Ladakh. In Ladakh? I have not seen a houseboat in Ladakh.
No, houseboat in Srinagar and then from there on. Why don't you go there? I'm told a lot of people go there now. It's go there and take a look for yourself. Empirical evidence will stare you in the face. The Himalayan car rally, which used to take place then in the former days, has now been revived. But my daughter's scheduled to go soon to Leh and Ladakh in that Himalayan car rally. So they're taking a sports car themselves and traveling up. She and her friends. That's
Justice
how flourishing it is
Justice
now.
Variava used to participate.
Yes, but your lordship is right, Justice Variava. But all affirmations from the reaffirmations from the other side about the congenial climate that now takes place in Jammu and Kashmir. But my clients are restricting themselves to the challenge to 373 and the proviso thereto, as also to the amendment to 367 brought about by CO 272. I'm not going into the question of 356 and the territorial reorganization. That's beyond tribal folk. And 356 really deals with the satisfaction of the president and the governor's report and so on, matters which are best dealt with by the government. So I'm not going into that. I'm going to these two questions only.
You're going to go into 373?
370, the proviso.
And
367 amendment, which replaced by CO 272, dated 5th August 2019, which substituted the word Constituent Assembly with the word Legislative Assembly. Incidentally, I might just mention that my clients are the beneficiaries subsequent to 5th August 2019.
actually, you very helpfully identified the 4 key areas in the case,
Yes.
which the case turns. 1, 370 itself, and the proviso to 370 bracket 3. 2, the use of the amending power under 367. 3, the reorganization. And 4, 356.
Those are really the 4 issues which arise in this.
4 areas, I would say, because there are issues which arise from.
So with regard to the latter two, I'm adopting the arguments of the state, of the government.
All right, how would you formulate yours so that then we
Yes.
can...
I've submitted written submissions
Yes, we have got that.
2 days ago. Yes. But briefly on the question of sovereignty, where does sovereignty lie? Because it then dovetails into the question, which are the subject matter of the 2 issues I'm going to deal with. Just a brief overview about the sovereignty question. And I divide it, sovereignty can be looked at in various different ways. There are many divisions, external, internal, political, legal. But I'm going to just talk about the political and legal sovereignty very briefly, these 2 issues. And as far as political sovereignty is concerned, there is no doubt that the other side has not even seriously challenged its political sovereignty rests with the union. And the clearest indication of that is the preamble. Political sovereignty rests with the union. Qua the state. And a simple look at the preamble, my lord, would indicate that. The preamble of the 2, the union and the federating unit of the state of Jammu and Kashmir, would reveal that. A point noted by Justice Nariman in the State Bank of India case. It also will kindly have a look first at our preamble very quickly. We, the people of India, having solemnly resolved to constitute India into a sovereign, the word sovereign is key, socialist, secular, democratic republic. Now, in contrast, the Constitution of Jammu and Kashmir has the following preamble. We, the people of state of Jammu and Kashmir, having solemnly resolved in pursuance of accession of this state to India, which took place on 26th October 1947, to further define the existing relationship of the state with the Union of India as an integral part thereof. So now the preamble itself makes no mention of sovereignty. In fact, the preamble is dealt with further defining the existing relationship of the state with the union as an integral part thereof. So it's an acknowledgement of the union's sovereignty over the state. This is political sovereignty. The constitution was geared towards defining the relationship of Jammu and Kashmir for the union as an integral part of the union.
Yes.
And first and foremost, the permanent residents of the state of Jammu and Kashmir are citizens of India. Although Mr. Lord may sometimes behave that he's not, but in fact he is. Now I come to the question of legislation. Legislative sovereignty is divided between the union and the state. And on a look at Article 370, which is the governing article of the relationship between the union and the state. Matters in the concurrent and union list acceded to by the then Maharaja are within the realm of the center, the union. And broadly speaking, one of the other parts of the Constitution within the jurisdiction of the state. And
but therefore, the sequitur of your argument would be that matters which do not form part of the instrument of accession in relation to which the union was given exclusive control,
yes.
the four matters.
Yes.
The legislative sovereignty would therefore continue to vest with the Jammu and Kashmir Legislative Assembly.
Subject to the power of the president to apply the provisions of the Constitution under B 1 and 2, but with the concurrence or the consultation of the state. So any provision, theoretically speaking, if those qualifications arise, if that concurrence or that consultation takes place, then the entire Constitution can be applied to the state of Jammu and Kashmir under 371. 373 is distinct from 371 because it's at a one stroke abrogation of the entire Article 370.
Therefore, Mr. Jethmani, you therefore also necessarily accept that there is a concept, sovereignty has two connotations.
Yes.
One, external sovereignty,
Yes.
which undoubtedly vests completely with the Union of India. Internal sovereignty, which is then distributed between the Union and the states.
Yes. Yes. That's a patent look at that. Nobody can deny that. But the Constitution envisages that from time to time, further and further, and that's been the, as has been pointed out repeatedly during the course of these arguments, that with the passage of time from 1950 onwards, more and more provisions of the Constitution have been made applicable. And some of them are those which were not originally applicable to the legislative or within the legislative jurisdiction of the center. But ultimate legal sovereignty rests with the Union. And well, that is Article 373. Article 370, sub-article 3, is indicative of the fact that ultimate legal sovereignty, in the sense that you can get rid of the tunnel altogether that connects the Union with the state legally and constitutionally. Ultimate legal sovereignty rests with the Union of India. And 373 is key, is one of the key issues in this entire discussion. It's in all these arguments, 373, and the reading of the proviso, the effect of the proviso. That establishes most of the issues that arise in this case, at least it sets a platform whereby the others can be. Absent that, there would be nothing else, which is why the other side is at pains to point out that after the Constituent Assembly dissolved or became extinct, 373 has no application. In other words, the substantive part of 373 is now swallowed by the proviso. The absence of the Constituent Assembly and the power of recommendation which was vested in it has now disappeared. That's their case. Now, on that proviso, I'll have something to say. But this is the sovereignty issue. Now, there is also Article 147, which is some indication of legal sovereignty of the state of Jammu and Kashmir. That's the amending part. That is an acknowledgement. The third part of C, clause C of 147, is an acknowledgement by the state of Jammu and Kashmir that they cannot touch the Constitution of India as applicable to the state of Jammu and Kashmir. About the issue of Article 373 and the proviso thereto, it actually dovetails into three questions which I'll just frame, which are at the heart of the controversy here. The first is Article 370 temporary or permanent? did the extinction of the Constituent Assembly of Jammu and Kashmir referred to in the proviso to that article render entire Article 373 OSHOs? And third, was the amendment by CO 272, dated 5th August 2019, to Section 377, to Section 367. Sorry, to Article 367. Article 367. By the addition of clause 4D, that article which made Constituent Assembly read as Legislative Assembly, was that constitutionally valid? About
Just since we have 55 minutes now to lunch, we'll give you time till 12:20. Mr. Guru, 12:35. Then we will hear the interveners for 2 to 5 minutes, and then we'll give Mr. Banerjee the interveners between 12:35 and 12:50, and Mr. Banerjee 12:50 to 1. That's the way we'll do it.
Now, because I have to read some extremely important constitutional orders, see, just very briefly.
Give us the page.
Yes, but I just want to read the portion that I'll tell your lordship what my argument. I'll come to it in a minute.
Well, let's get to the argument.
Yes, yes. Let's not waste time management. I agree.
Yes.
My lord, as far as the temporary and permanent part is concerned, two issues have already been discussed. One is Article 370 is a provision that is a part of Chapter 21 of the Constitution of India, which deals with temporary provisions.
Yes.
Lordships have already noted that. Second is the title of the article, which describes its provisions as temporary provisions with respect to the state of Jammu and Kashmir. And my lord, third is the effect of the proviso requiring the prior necessary recommendation of the Constituent Assembly of Jammu and Kashmir before the president can act under 373(1).
Your contention is that the Constituent Assembly of Jammu and Kashmir was necessarily limited in point of time and purpose
But I'll tell,
Time, the framing of the constitution for the state, purpose, once that purpose was over, it had to come to an end. That's your submission.
and one of the proviso, and not just one judgment, which I'll just give your lordship the citation, that it is a principle of construction that unless clearly indicated, a proviso would not take away substantive rights or powers conferred by a section or a subsection. That's Madhu Gopal's case. And the citation is in my written submissions. Paragraph 7.
Just give us the volume, PDF
Yes.
page and para.
But I've annexed it to my note. But if your lordship wants it in the PDF,
Give it to us here, we have taken it.
I don't think
You
it's
don't have
in
to
the-
flip.
it's not in the PDF. I'm not.
It's not,
It's not in your lordship.
Case law PDF.
case law PDF.
It's a very short judgment, literally two and a half pages.
Anyway, GP Singh's interpretation of statutes, a whole section on how to construe a proviso.
Yes.
Sometimes it's explanatory, sometimes it's an exception, it's clarificatory.
But the principle seems to be that unless clearly indicated, it would not take away the substantive rights conferred by the main section.
All.
I'm not just a look at 373 and then I take you to my submissions on this most important point.
Yes.
Now, the Constitution and its provisions have to be looked at the perspective of people drafting it in 1950. Well, in 1950, when they did not know who the ultimate constituent power would be in Jammu and Kashmir. Essentially, what was 370? 373, which talked about the article ceasing to be operative altogether. Because it was the terminus of the entire article, that article required the constituent power on behalf of the Union, acting on the one hand, which is the President of India, qua 370 and Article 3, qua Jammu and Kashmir through Article 370, he was acting as a constituent power. And on the other hand, the constituent power for the state of Jammu and Kashmir at that time was the Constituent Assembly. All documents from 1948 to 1950, all constitutional documents indicate that a Constituent Assembly for the purpose of framing a constitution was necessary, and that was the way forward, which is why Article 373 referred to the Constituent Assembly. But that didn't mean that once the Constituent Assembly completed its task, which was the task of framing the Constitution, that Article 373 would have no meaning, it would be ocious. Now, on the contrary, the COs issued from 1948 onwards, and now this is important, indicate two things. I'll just take a lot very quickly through those COs now.
What do they indicate?
Yes. First, they indicate expressly that the Constituent Assembly and the Legislative Assembly, insofar as it applies to Constitution of India, are synonymous. In other words,
Come again, the Constituent Assembly
and the Legislative Assembly are synonymous. I'll point out that expressly.
Where do you get that from?
From the various orders right up to 58. That they are to be read as the same. They are to be read as the same. Now, your Lordship may kindly see straight away The first one, which is CO10. CO10? What's the date? CO10, 26 January 1950. Now, this was the same time as the Constitution. Adoption of our Constitution. 26 January 1950. This CO. CO.
So what part of CO10 are you relying upon?
Second schedule. Is it the PDF page?
Just give us the volume and page,
Yes.
just so that we have it at one place.
Documents, volume 3, PDF page 7.
What does the second schedule do?
Now, the second schedule says, Articles 54 and 55 shall apply, subject to the modifications. Now, Articles 54 and 55 refers to the elections for the President of India.
What's the PDF page number?
Yes.
Page 7.
Page 7.
7. In documents, volume 3.
Volume 3?
Yes.
Yeah.
This is in column 3 of the second schedule. That the reference to the elected members of the legislative assemblies of the state and to each such, has the Lordship got it, man?
Yes.
And to each such elected member shall be deemed to include respectively a reference to the members of the Constituent Assembly of the state.
Because there was no legislative assembly at all.
No legislative assembly. I'll show you. There was no, absolutely right. There was no legislative assembly at that time. But even when there was, so look, that's the whole point. The point is, it was deemed to be a legislative assembly for the purpose of our constitution. Why was this necessary? In 55, they were trying to get members of the Legislative Assembly of Jammu and Kashmir.
Right, which is the next point, which
Yes.
is the next article,
The next order. So by a deeming fiction, the Legislative Assembly members of the
Give us
Constitution.
the next one because we are now
Yes.
5 minutes short of the.
Yes. Then my lord, the next one is CO 39. That's at PDF page 10. See, volume 3 again, PDF page 10.
CO 39.
PDF page 10.
Yes.
Reference to the elected members of the legislative assemblies of the states and to each such elected member shall be deemed to include respectively a reference to the members of the Constituent Assembly of the state and to each such members. Now, in CO 48, which is the next one, I'm running through it now, and this was in 1954. The date of CO 48 is 15th May 1954. Now, in this CO,
That CO you're saying?
so that's about volume 3, PDF page 13. And I'm reading at page 18.
That is CO number?
48, dated 15th May 1954.
Right, that's a 54.
Yes.
Page 18. All right.
Now, in this CO, for the first time, previously it was done by COs. But for the first time, Article 367 was amended
Right.
as applicable to J&K.
is it relevant for your argument that Constituent Assembly means Legislative Assembly?
Because that's what the Union of India has done. They've amended 367.
Clause D.
Yes, yes. That's CO 272, which is under challenge. The same procedure was undertaken in 1954. For the first time this was done.
This was also pointed out to us by, I think, the learned solicitor.
In fact, that's in his list of days. This is the first exercise of 367 power.
But it was even, yes. But even earlier, they were synonymous. The Legislative Assembly and the Constituent Assembly. It emanated from 1948.
This 14th of May 1954.
Yes, no, 15th of May 1950.
Right, when there's no Legislative Assembly in Jammu and Kashmir.
No, it's not. But now an amendment is made that they will be the same. Even when there's no Legislative Assembly. And now we are not talking about for the purpose of a presidential election. This is now for every purpose.
All right, which is the next CO?
Then, my Lord, Your Lordship might just see a provision in the Constitution of Jammu and Kashmir, 85(2), 85 subsection 2. This is at PDF page 56, volume 2.
PDF page?
PDF page 56. Until rules are made under subsection 1, the rules of procedure and standing orders in force immediately before the commencement of this constitution with respect to the Constituent Assembly, while discharging the functions of the Legislative Assembly, shall have effect in relation to each house of the legislature. There was only one. Subject to such modifications and adaptations as may be made therein by the Speaker of the Legislative Assembly or the Chairman of the Legislative Council, as the case may be. My Lord, substantively and in matters of procedure, the Constituent Assembly and the Legislative Assembly. In fact, what emanates from all this is that the Constitution.
But Mr. Jetnani,
Yes.
the fact still remains that after the Constitution of Jammu and Kashmir was framed
Yes.
on 26th of January 1957,
Yes.
Article 367 4D was again amended.
Yeah.
So delete clause D.
Yes. But my Lord,
So that equivalence between the Constituent Assembly and the Legislative Assembly ceases the moment the Constitution of Jammu and Kashmir is framed.
Lordship is absolutely right. Now I'm coming to that last one in 58. That's the last piece. But my Lord, what happened is.
That you will find at your volume 3, page 25.
Yes, Your Lordship is at page 25. That's. The point is, all this shows that the Legislative Assembly, and why was this deleted? This was deleted because after the dissolution or the extinction of the Constituent Assembly, the constituent power in Jammu and Kashmir was now the Legislative Assembly. The power of amendment, in Article 368, it's in virtue of its being a constituent power that Parliament can amend. This is also recognized by at least 3 judgments in Indira Gandhi's, Nehru's case with Raj Narayan. I go back to the beginning of what I said, right at the outset, that the idea was that 373 being the final step, after which Article 370 altogether ceased to exist.
The only distinction is that a legislature which exercises the power of amendment
Yes.
is not a Constituent Assembly. It's exercising a constituent power.
I agree it is. I agree it is. But otherwise, the alternative interpretation would be that abrogation ceases to exist. You can never abrogate Article 370. That would be the alternative conclusion. We have to see why Parliament amended to Article 370 through 367 in the manner which it did. That's the whole challenge to 272. That is the whole challenge. And it did so because not only was it synonymous for they wore two hats. The Constituent Assembly wore two hats. The same people, the 75 people who constituted the Constituent Assembly in 1951 when it was convened, were the same people who were also members of the Legislative Assembly.
Argument of the learned solicitor is that independent of the amendment of Article 367,
Yes.
370 bracket 3 and the exercise of that power still stands.
Of course it
And
stands.
it still survives.
Because I'll tell your lordship why.
To go as far as, according to him, he has not pitched it, though he said, look, 367 has also been used in the past.
Yes, yes,
The 3 times it was used.
yes.
But he has said, independent of 367,
It can still be done.
power
Look,
will be-
which is why I come to my next point. And that's one of the 360s. They became the successors, They were certainly the successors. If there was any constituent power which could replace the Constituent Assembly in the proviso, it was certainly only the Legislative Assembly. Now, your lordship is right, 367 could not be the source that did not necessarily have to be the source for that replacement between the Constituent Assembly and the Legislative Assembly. Did not have to be a source. But it was implicit in any event. All 367 did, or the amendment to 367 did, by CO 272, was to recognize an implicit position. It was not only synonymous for a substantial period of time, but it was a successor. And CO 272 did not make a substantive change. It made a change it was a clarificatory change, which was already inherent, which was already implicit in Article 373 proviso.
All right, anything else, Mr. Jaflani, now?
But now the Damnu's case applies. Please one look at Damnu to consolidate this argument.
Damnu we have seen, we'll have a look at it.
Just some paragraphs with special emphasis.
Which are the paragraphs? Just give us.
Yes, I'll give a lordship the paragraph. Paragraph 25. Oh, no, I put in my list. Lordship, just gives me a minute. Yes, my lord, the factual situation, which my lord makes the question of law decided clearer, is in paragraph 6, 1, 7, and 8.
Of Damnu.
Of Damnu. That's the factual situation. But if your lordships recall, it was that change. It was that change of Sadr Riyasat to the governor of Jammu and Kashmir. And my lord, the findings are at 19, 22, actually 19 to 28. 19 to 28. And though the 367 was upheld by that constitution bench, the amendment to 367 was upheld by the constitution bench on the ground that it was merely a clarificatory. It was not an amendment of substance. So also here, I bring my submission within the 4 corners of Damnu.
All right.
That this was inherent.
Anything else, Mr. Jaflani?
No, well,
Because now the second point you have covered is.
Well, and as my learned friend pointed out, that Damnu also refers to it. Damnu says it's sought in aid of its the judgment, Section 18 of the General Clauses Act.
Yes.
So, my lord, General Clauses Act applies because it's my contention that the Constituent Assembly is the successor. The Legislative Assembly is the successor, and Section 18 of the General Clauses Act will squarely apply, as it does. So the powers vested in the original authority will devolve to the successor authority. In this case, the Constitutive Assembly, the Legislative Assembly.
Thank you, Mr.
And I'm-
Chairman. Thank you, Mr. Chairman. Yes, Mr. Guru.
Made these. I appear in IEA Melod's 9596 in WP Melod's 1037 of 2019. Melod's, just a minute, Melod's aside.
Who are the applicants?
The applicants, Melod's, are persons, displaced persons from that portion of Jammu and Kashmir, which is now called Pakistan occupied Jammu and Kashmir. They represent that set of people, Melod's, and their interests. These are the interveners. With prejudice to my time limit, which my lords have given, just an aside, my lords, I'm reminding myself of being that apocryphal son-in-law under Hindu law, my lords, which Sir Alladi referred to. Apparently, my lords, there was a very intricate problem of Hindu succession under Mitakshara and Dayabaga law before an English judge. The questions were getting so complicated that the judge tongue-in-cheek asked Sir Alladi, what would the son-in-law get? I believe Sir Alladi said, whatever he is able to lay his hands on. That Lords, seems to be my position in terms of Lords, both time and submissions to really.
So what are the key submissions?
Key submissions, I'll refer to this, Lords. The rights perspective is probably the decisive factor in determining, my lords, the tenability of the challenge which has been mounted by the petitioners. In other words, my lords, the rights perspective will trump or override all or any contentions or allegations of processual infirmities. And the reason why I'm making the submission is this, my lords. Whether it be these intervening applicants or any of the other intervening applicants whom Mr. Salve represented, Mr. Giri represented, or for that matter, Mr. Jethmalani represented, they represent a cross-section of people from Jammu and Kashmir who have suffered discrimination and loss of rights. Therefore, they impugn COs which make provision for rights for such people across the spectrum. The validity will have to be seen in that perspective and in that light. That's my submission for my lord's consideration. For example, my lords, these intervening applicants whom we are referring to, they are probably, my lords, the first victims of the problems which occurred during partition. When the aggression took place and the incursion came, these are the persons who were displaced by force of circumstances from those areas, Mirpur, Gilgit-Baltistan and all those places. They moved therefore to other parts of Jammu and Kashmir and to other parts of India. Now, what is really the problem that they have suffered over the decades now? Because of Section 6 of the Jammu and Kashmir Act, Jammu and Kashmir Constitution, and 35A of the Constitution of India is applicable to Jammu and Kashmir. 6 purported to set out who permanent residents are. (35A) introduced, my lords, by constitutional order in 1954. CO 48. That, my lords, provided that permanent residents, as defined in 6, they will get certain benefits. And the fact that persons who are not permanent residents will not get those benefits cannot be called in question as a matter of justiciability.
Guru, just one clarification.
Yes, Manoj.
People who came from the Pakistan occupied Kashmir,
Yes.
they were not given rights under 35A?
No, for the reason why, I'll tell my lords why. Because that referred to permanent residents. Permanent residents as defined in the Act is any citizen of India, but subject to 3 important riders. Rider number 1, the person must be a state class citizen 1 or 2 as of 14th May 1954. 1. 2, he must be ordinarily resident in the state of Jammu and Kashmir during a period of at least 10 years prior to that date. So the date is shifted back to 1944. That therefore, my lords, meant that even those who were their citizens in Jammu and Kashmir in their own right, because of the external aggression during September, October of 1947, they are excluded. That's where the pinch is, my lords.
If they had settled down in other parts of the country, they would have got citizenship.
No, they would have had to be only
Other parts of the country.
Yes, they won't get. If you're in Jammu and Kashmir, yes. But if you went to other parts of the country, you won't get.
Sorry, you're saying
Yes.
the other way around.
May I show 6, my lord?
You're
May I
saying
show-
the other way around.
No, may I show 6, my lords? Can I show 6? Give me 6. Just give me 6.
Jammu and Kashmir Constitution is in part 1
Yes.
of the document. Part 2. Part 2.
Volume
2.
my lords, page 18.
Well, I'm sorry to interrupt. There are 10 petitions here which challenge 35A. Well, those have to actually be de-linked because we're not here concerned with the challenge to 35A. We're concerned with 370. So, well, all that is fine, but that's not to be decided by your lordships. If this is upheld, if what the union is saying is upheld, this is unnecessary.
That's why
Doesn't exist.
It's simple. Therefore, we are going into this.
I'm only saying, Malaz, this is only to
Let's-
take up the time of the court. That's all.
Every person, I'm at my lords, volume 2, PDF page, my lords, 18. Every person, may I read it, my lords, is deemed to be a citizen of India under the provisions of the Constitution of India, shall be a permanent resident if on the 14th day of May 1954, he was a state subject of class 1 or of class 2, or having lawfully acquired immovable property in the state has been ordinarily resident in the state for not less than 10 years prior to that date. Any person who before the 14th day of 1954 was a state subject of so and so, and who having migrated after 1st day of March 1947, this is an anomalous provision. I'll just show that, my lords. So the first part is 6.1. That talks about 2 dates, 1954 and 10 years prior to that. Second,
It's an alternative. A and B is an alternative.
that's right. Or, that's right. That's right. But then in terms of actual application, they have always been applied together. All these are persons.
They have been applied, treated as cumulative.
Yes. You are outside Jammu and Kashmir. You don't get it. In fact, I've given in my application, my lords, the case of how 8,700 people and odd people left that place during that time, during partition. Today, my lords, after the promulgation of the impugned COs, at least 23,000 people have received domicile certificates. About 24,000 people. We have mentioned that in our submissions.
So state subject of class 1 or clause 2
Yes.
is defined in clause 3.
Yes.
Subsection 3.
Yes.
Namely, that refers you to
1927.
So
That's right.
you're out there.
Yes.
You don't come in there.
No. In fact,
Clause 2.
no, because by 47, by 44, what happens is this, my lords. They expect you to be holding property as of 1944. And even though I qualify, in fact,
Let's say in POK, they're not governed by clause 3 of section 6.
no, my lords, what will happen? They will be governed by clause 3. That's why I'm saying it is applied cumulatively. You should be a state citizen, state subject of class 1 or class 2, and you should have been holding.
It says or.
No, but cumulatively it's being applied where you should have held property as of 44.
But then, Mr.
No, all I'm saying is this.
Mr. Kishan, I don't think 2 can be read as cumulative because it imposes a condition of owning a movable property.
No, I follow.
That owning property.
No, no, I understand. But the fact of the matter is.
It cannot be.
The fact of the matter is, my lords, they were entitled, but they have not been provided. That's the factual position.
Only thing is because under A and B, if you're not under A, if you're class A and class 2 citizen, then you have to go for 1927.
1927.
get documents of 1927 will be very difficult for anybody.
That's another aspect, absolutely. I bow down to that. I
Now
bow
in
down to that.
clause B, prior to that date refers to which date? 14th of May, 1954?
Yes, that's right, 1954. That 14th of May, 1954.
Yeah, for clause A, subsection 3 applies.
That's right,
There
27.
is a 1927 order.
Correct.
For clause B, you have to own property and you must have been ordinary resident at least for 10 years prior to 14 May 1950.
I vote on. And
So
that date,
anybody from 14th of May 1944 onwards
that's right.
comes within the
Should
purview
have,
of
should have
clause
held
B.
property. And that 1954 date, my lords will recall, is the date of CO of 1954.
That's also very odd because to
Yes,
say that you must own a property to get citizenship.
exactly,
is-
exactly, exactly. Now, one more thing, my lords, one more aspect, my lords. Please have a look at 2, section. Yeah, that's right. Yeah. It's a
You're really trying to say is you're supporting the CO 272 and 273
correct.
by pointing out the anomalies which would otherwise arise
I
as a
vote
result
on-
of Article
I vote
35,
on.
Section
The
6 and 35.
I bought on the challenge, my lords, would really mean that they want to resurrect, amongst other things, this and 35A. That's the point.
Of course, challenge to 35A has.
It stands,
been
it stands. But
Kept aside.
I vote on, my
An
lord.
application to assist. Otherwise, that challenge has been kept aside to await the fate of the decision.
I vote on, my lords. But then I
Provision-
am saying,
a
I'm
provision-
saying that this is important.
A provision which doesn't exist as of now cannot be challenged.
No, that's true. The effect of upholding the COs is to ensure that, my lords, this anomaly doesn't exist anymore. I am respectfully submitting, my lords, that I am placing this submission from the perspective of rights which are being made available by the impugned COs. That's the point I'm making. One more anomaly to add to what fell from my lord Justice Khanna may have a look at it. Section 2, subsection 2. Any person who before the day of 1954 was a state subject of class 1 or class 2 and who having migrated after the 1st of March 1947 to the territory now included in Pakistan returns to the state under a permit for resettlement in the state of a permanent return issued by or under the authority of any law made by the state legislature shall on such return be permanent resident of the state. So you make an exception out of this by saying those persons who may have gone to Pakistan, if they come back, they'll get the benefit.
Any persons also who was.
Yeah. The anomaly is writ large.
No, this included in Pakistan will not include Pakistan occupied.
No, it won't. That they are very clear.
It will not include Pakistan.
No, it won't. That's why a separate provision is brought in.
It will be portions other than.
Other than
Pakistan.
POJK. There is one other, my lords, very ironical aspect. The Jammu and Kashmir constitution makes provision for seats for POJK in the assembly, but says because it is under. 1 minute.
Time is up.
I know, my lords. That's why. No, now there are 2 other perspectives I'll place and then I'm done, my lords. In fact, this is something which nobody has referred to. That's the reason why I'm even troubling my lords with some of the nitty-gritty of this, my lords. So this is one aspect. 35A, just have a look at that for a minute, my lords. Now, because there's a striking parallel to 31B under the constitution. Koilo, please see the kind of dilution which took place in Koilo. Just have a look at 35A for a minute, my lords. This will be volume 1, PDF page 99. Okay. Notwithstanding, may I read the words? Notwithstanding anything contained in this constitution, no existing law in force in the state of Jammu and Kashmir, and no law hereafter enacted by the legislature of the state, defining the class of persons who are or shall be permanent residents of the state of Jammu and Kashmir, or conferring on such permanent residents any special rights and privileges, or imposing any other persons any restrictions as respects employment under the state government, acquisition of immovable property in the state, settlement in the state, or rights to scholarship or such other forms of aid as the state government may provide shall be void on the ground that it is inconsistent with or takes away or abridges rights conferred on the other citizens of India by any provision of this part. Now, 31B, my lords, under the Constitution provides that anything included in the 9th schedule shall be immune from challenge on grounds of violation of Part 3.
Guru, now I also note that in your written submissions, you have
Yes.
really highlighted, what was the anomalies and what has been restored now.
Exactly.
The rights perspective. So
That's right.
I think let's go into the
Just
next step. Yes.
three more things, my lords. I'll take only 3-4 minutes, my lords. Now, 31B in COILO, my lords, very extensively referred to the foundational value of the fundamental rights. Golden triangle of 14, 19, and 21. I've given all those paras in my submissions, my lords. In fact, I've given the extracts of all those paragraphs in COILO. Now, ultimately, my lord said, you cannot take away judicial review and any law included in the 9th schedule can be tested on the anvil of basic structure. Now, surely you cannot have a position, and that's what petitioners are bargaining for. What was there in the original constitution, my lords, this is the approach of this honorable court. The petitioners can't bargain for a position where the Jammu and Kashmir constitution, which is admittedly inferior in terms of, my lords, the constitutional governing instrument than the Constitution of India. They have something better than that. This is the kind of importance which has been given under the constitutional scheme of India. In fact, 31B itself, my lords said at one part in paragraph 78, just make a note of it, the validity of 31B was not in challenge and therefore my lords did not go into it. My lords assumed that in Shankari Prasad and in Sajjan Singh it was upheld, therefore my lords didn't go into it. But instead, judicial review cannot be excluded. And you cannot say, by placing it there, I'm making it immune to challenge. That's precisely what 35A purports to do. That's the second part, my lords. Third part. Ultimately, my lords, all the nuts and bolts and the nitty-gritty looked at. What does it come down to, my lords? The basic structure is the ground norm. That's the touchstone on which any constitutional decision making has to be considered. The validity of any constitutional decision making has to be seen. Today, what are they, my lords, arguing in terms of basic structure? At the highest, apart from, if I may say so, diffuse arguments of fraud on constitution. Two square features which they want to invoke, my lords, in various forms. One is federalism. The other is, my lords, representative government. So far as representative government is concerned, I think that already the solicitor has pointed out, it's a Puducherry model, there is representation. So far as federalism is concerned, the highest that they are able to put it on is some kind of a derivative form of federalism based on what my lords have said in the 2023 NCT judgment. That's the highest they want to put it at, where they say that my lords are referred to an asymmetric federalism. Paragraphs 40 and 41 of 2023, my lords have been given, the citation is there in my notes of submissions. What they want to say now is, asymmetric federalism has been recognized. Now please stretch this and say, the multisymmetric federalism of 370 should also be taken to be a basic feature of the facet of federalism. That's the argument. I'll give the page numbers of Dr. Dhawan's arguments. Page 280, page 211, volume 1 of submissions. After extracting from my lord's decision in NCT in 2023, they say that this now has to be stretched further to say multi-symmetric federalism. There, para 40 and 41 of 2023 at the risk of carrying coal to Newcastle, my lords. My lords, interestingly, have referred to 371 and all those provisions for various states by way of special provisions. My lords there refer to how they are special provisions in 371. And it is on that basis, by relying on the marginal note. My lords have pointed out how constitutionally some kind of asymmetric arrangement has been made. So it is on the basis that it is a special provision in 371. Today, what they want to do is equate 370, which is temporary, with 371 special provision. I hope I make myself clear.
Yes, yes.
Therefore, that is why I said it's a derivative argument they want to make. 371, my lords consciously referred to the marginal notes and said how these are special provisions. And that's how they provide for special provisions. That cannot be stretched, my lords, to say that it has to be applied to 370. The temporary character, nuts and bolts of 370, all of them have been argued, my lords. I don't want to take the time anymore. I'm adopting those arguments. In the light of that, my lords, I would respectfully submit. In fact, the impugned COs are reflective of transformative constitutionalism. What was argued by Dr. Dhawan, in my respectful submission, the boot lies on the other foot. The impugned COs ensure that the Constitution of India, with all its plenary scope, applies to the state. In my respectful submission, my lords, the challenge of the petitioners is really a contradiction in terms. Because this is a case where the application of the Constitution of India, the plenary document, is sought to be challenged. The effect of the COs is to ensure that the entire Constitution applies to the state, with all Part 3 rights, with all the other provisions. And even on federalism, my lords, there is one other portion in the opening remarks of Dr. Ambedkar while placing the draft constitution, my lords, before the assembly, constituent assembly. I've extracted. No, there is another portion apart from what Mr. Giri read. So I extracted that in my submissions. My lords could have a look at that. Therefore, my lords, in sum and substance.
Thank you, Mr.
In sum and substance, my lords, this is for perpetuation of vested rights. And the COs, my lords, make provision for realization of rights under the Constitution. I'm obliged.
Thank you, Mr.
Yes.
Who are you appearing for?
I am for the writ petitioner who had filed the writ petition in January 2018 against the effacement of all articles in respect of me in relation to Jammu and Kashmir. Part 3, effacement of Part 3, a core value from the Part 3. I challenged that before this court, and that has been tagged. Enough has been argued, but I am arguing for class, that's Radhika Gill versus Union of India.
Which is that?
Radhika Gill versus Union of India, and my synopsis is at page, the compilation is 426. I'll take only 2 bits, my lord. This Radhika Gill and the other person belongs to that class who are descendants to those persons who have been lifted from Gurdaspur to Jammu and Kashmir in 1957 to handle the sanitation problem which had arisen on account of the long strike in Jammu and Kashmir. So they were settled in the outskirts of Jammu and Kashmir, and my lord, that now has converted now with the passage of time. Those are the slums, no property rights, etc., no education rights, etc. Now, my lord, your lordship may kindly see my prayer. The whole effacement of Part 3 in relation to Jammu and Kashmir, I have challenged in my writ petition. Your lordship may kindly see the Solicitor General referred to Article 14 effacement also. Your lordship may kindly see 35A, Clause A. What exactly it does? It does one thing, my lord, delegating the power to the state legislature to define the permanent resident and not challengeable. That's what, my lord, the delegation has been done to the state government, state legislature, my lord, in this class 1, your lordship, defining the class of permanent resident and delegating it to state legislature and not challengeable. So, my lord, your lordship have not allowed such a delegation to the state government so far as the Part 3 aspect is concerned. So that's what the solicitor said, that core value of Article 14 has also been taken away. And with the aid and assistance of this delegation, Section 6 was incorporated, and this is nothing but a homage to defined ancestry and none else. Whosoever is there on a particular cutoff date, I was there in 57 only, my lord. So my predecessors were in 57, and we were there, and now we are denied. I am born there, I am born there, and at least no fundamental rights are available to. That's why I challenge that right to education. Right, Section 6 has also been challenged in that petition. Now, my lord, your lordship, I'm now, so far as my synopsis is concerned, paragraph 17 and subparagraphs have dealt with three aspects. One is the powers are precedent are constant in nature. The lordship may kindly see paragraph 7, subparagraph B.
That's argued.
Now, one thing. Relationship between 368 and Article 37.
That's been also argued.
No, yes, I have taken this. I have taken this here in that.
Thank you.
Thank you. Anything else? Yes. Yes. What about you?
I am hearing in my lord, I number 153121.
I number
153121.
15153.
153121 of 2019. That's Roots in Kashmir. Roots in Kashmir is an organization which is espousing the cause of Kashmiri migrants, now called displaced persons. Since 1989, there are 5 lakh people.
What is the
That's one. That's one petition. Number 2 is Dr. Charu Wali Khanna. That's a substantive writ petition in 2017. 369. That is. Just give me number. What's the number? 396 of 2017. Submission is, my lord, I am allowed given detailed written submission that are conjoined written submission, my lord, volume 3, page 444 to 456. And, my lord, for convenience, my lord, I have filed a small note, 3-page note, my lord, which was taken on record, my lord. I read it, my lord.
We'll have a look at it, but you can just sort of in 1 minute just highlight what is the central point.
My lord, I'll say, my lord. I'll say, my lord, the instrument accession dated 26/10/1947, my lord, is final and issue of proclamation, and the Article 1 and is completely applicable, my lord. So it has, it's being an integral part of the India, domain of India, my lord. Then, my lord, I say, my lord,
something which has not been argued.
My lord, it's not, my lord. I say, my lord, with respect to the Article 370, which is being raised, my lord, herein, that the devolution of power of Constituent Assembly is transferred to the Legislative Assembly, as there is no Constituent Assembly as on 57. Therefore, it's not the.
That has already been argued so many times.
No, it's not, my lord. It's not, my lord. Concurrence given to the government of the state, but also repository. Ratification has been done to the Parliament. So, absolute majority, Parliament has rectified the decision. One is that, my lord. 2 is, my lord, and my lord, it's not a basic structure. As my lord held in, my lord, I am going to.
Got the point.
I have, my lord, relied in my lord. I relied on my 1973 for SEC volume 15, my lord, in Keshananda Bharati of Justice Khanna. He has given that, my lord. And, my lord, then Bomai also, it's not a federal, it's a quasi-federal, my lord, state. Then Puran Lal Lakhanpal and, my lord,
that is now being covered.
Modification. I had added one judgment, my lord, because I could hold that. That is, my lord, S. Sant Singh and others versus State of Jammu and Kashmir, reported in 1959, Jammu and Kashmir, page 35. That's a full-fledged judgment, my lord, which deals with modification clause of, my lord, Article 30, my lord, Article J&K Tenancy Act, my lord. That is AR 1959, Jammu and Kashmir, page 35. Dealing with the challenge to provisions of Jammu and Kashmir Tenancy Act inserted in 9th schedule was upheld and did not violate any of the fundamental rights conferred under Article Part 3. See, this is, my lord. Then Kohelo, as my lord said, that it's not a fundamental, it's not a violation of fundamental rights under Article Para 102. My lord, Kohelo is that page, my lord.
Kohelo has been argued so many times. Everybody has referred to Kohelo.
Then my lord, we have very less time, my lord. That's why, my lord, I'm just going through all these things. My lord.
To Mr. Dwivedi.
Indra Sani, my lord. Indra Sani, my lord.
Assigned to Mr. Dwivedi.
My lord, 35A, my lord, I have challenged the substantive writ petition, my lord, in 2017, which a notice was issued and this was referred to the Constitution bench in that time only, my lord. Then it was tagged along with this, my lord. So I have 4 judgments to cite on, my lord. Indra Sani, that's equality. 19, my lord, what has happened in this, my
You
lord?
put it in your note.
My lord, I said, my lord, 27 and 32 notification, my lord.
We have 3 minutes now. Let's hear some other
I'll
people.
take 3
Otherwise,
minutes. I'll take 3 minutes.
Let's-
3 minutes. I'll take 2 minutes. I'll take 2 minutes.
No, no.
27.
You have to close at.
My lord, 27 and
Yes,
30.
Mr. Banerjee, what do you
I'll
have
say,
to
my
say?
lord. I'll say why.
My lords, I am,
We'll read your written submissions.
Then one. Then.
my lords, I am appearing in IA 146764, my lords.
My lord, just petition from 20.
My lords allow.
No, that absolutely not. You have to conclude. We have to conclude by lunch. I mean, we had made that clear yesterday.
My lord, by 1 minute they'll take, my lord. My lord, I'll say, my lord. I'll say, my lord.
When we
Mr.
said
Judge,
that
we have,
period of time.
My lord, I had.
We had said that, look, we are going to conclude at 1 o'clock. We had requested everybody to so structure their arguments that the others who follow have time. We are not going to cross 1 minute after 1 o'clock for
Yes,
this
my
side.
lord. I'll read the affidavit, my lord.
Absolutely
I'll read the affidavit, my lord, which I mentioned in the morning, my lord. My lord.
You can argue for the next 3 minutes, but you know what the consequences. We are rising at the stroke of
My
lunch.
lord, I read. My
Well,
lord,
yes.
let
We
me
are
read-
starting with the rejoin.
let me read the affidavit.
See, this is not fair. You said,
This is
I will give my
filibustering.
half an hour to Mr. Dwivedi.
My lord, half an hour to me, my lord. I could curtail my half.
Mr. Judge, you
Half an
specifically
hour.
said
Gave your half an hour to.
My lord, can I read
that
the
I'm
affidavit?
giving my half an hour to Mr. Dwivedi.
My lord,
But
can I read my affidavit, my lord?
We'll read it. What is
Read
it?
it, my lord.
we are rising at 1 o'clock.
In my affidavit, my lord, I'm making only one submission, my lord.
The
Let
element
Mr.
of
Lone
civic
make a
consciousness
statement or
must also
affidavit
apply
that
to legal
effect
arguments
that
and
he's a citizen of India and he doesn't, my lord, support terrorist states, my lord. Let him put an affidavit, my lord. Mr. Sibbal, learned counsel is here, my lord.
All right, 1 second.
Please.
Just 1 second now. Just 1 second.
Please.
Mr. Agarwal, what point do you want to make? Just formulate it. Come.
My lord, affidavit, my lord.
Diversity, the element of Dr. Chavan is.
My lord, only one thing, my lord. My lord, Mr.
Please,
President,
your time is over.
President of the bar is
Your
here, my lord.
time
Jammu Kashmir President. My
Your
lord,
time is over.
My lord, I was appearing for Jammu and Kashmir High Court Bar Association. My lord, President of the bar is here, my lord. He wants to say something. My lord. That's all, my lord. I am curtailing my argument.
We are in charge of whom we will hear. You are not in charge of who will follow you.
My lord, I don't.
Mr. Kanu Agarwal.
Okay, that's, my lord, I leave it to my lord.
Short pager that I have submitted. Federal diversity, my lords, Dr. Dhawan sought to rely on the judgment of R.C. Podial. If my lord sees, to my understanding, federal diversity in the Indian Constitution exists on a two-dimensional plane. At the center would, as far as I understand, would be the classical states, would be the classical understanding of a state, the state which has fully governed by Schedule 7 and other provisions of the Constitution. To the right of it would be states which have limited special features, would be states like the limited features like Gujarat or Maharashtra, all taken through by Dr. Dhawan. Thereafter would be states which say fall under the 5th schedule and the 6th schedule, and some other states which have further special features. To the right end of it, perhaps, was the erstwhile Article 370. What the petitioners forget, my lords, is that there is a scale to the left of it as well. The scale to the left of it is the union territories with legislature, is the union territory of the GNCT of Delhi, and further, perhaps, pure and simple union territories. Therefore, federal diversity, my lords, it's undoubted that diversity is a constitutional fact, but not all constitutional facts can be elevated to the level of basic structure. When we adopt the identity test in terms of identification of basic structure, not all constitutional facts become basic structures. R.C. Podial was relied upon to further the argument that this diversity, a manifestation of which was Article 370, erstwhile Article 370, is a part of basic structure. Incidentally, my lords, para 128 was read in R.C. Podial. If my lord sees the last 3 lines of para 128, I think that those last 3 lines itself completely demolish the case of the petitioners on federal diversity, because those last 3 lines itself indicate that these provisions which were in consideration in R.C. Podial were for a limited transitional period. The word transitional has been used. Therefore, my lords, as far as the fact that federal diversity may be integral, it would not necessarily lead to it being a basic structure. The method and the methodology adopted by the union, whether under 368 or 373, has been fully taken care of. I don't wish to address it further. The second point is on, my lords, Constituent Assembly and the nature and the nomenclature of Constituent Assembly. Mr. Gopal Subramaniam specifically highlighted that there are no hierarchies. That was his assumption, that there are no, at a normative level, that's an absolutely correct statement. There cannot be any hierarchies in Constituent Assembly. However, there are not many things that move on a normative level in Jammu and Kashmir. There are three facts in this regard that my lords need to see. There are two kinds of constituent power. One is original constituent power, and the other could be derivative constituent power. It was on this jurisprudential basis that Keshwanand Bharti was delivered and thereafter other judgments, which state that the original constituent power is always with the original constituent assembly, the plenary power. But derivative constituent power is something that is always with further legislatures, the parliament in this case. Therefore, the question that we need to interrogate is whether the Constituent Assembly of the Jammu and Kashmir Constituent Assembly had any original constituent power. The three facts, which according to me clearly point towards the fact that they had no original constituent power, were A, it was established under the proclamation of a Maharaja that had already signed an instrument of accession. Number two.
Yes, one second.
It's there in the three page.
Yes.
Number two, the Maharaja had already issued a proclamation dated 25/11/1949, recognizing the supremacy of the Indian Constitution. And number three, unequivocally, Article 1 was in force. So on the date in 1951, when the proclamation to establish the Constituent Assembly of Jammu and Kashmir was issued, the Maharaja, who was not a sovereign, could not have passed a better title than what he had. If he was not a sovereign, the Constituent Assembly of Jammu and Kashmir could never have been a sovereign Constituent Assembly, could never have established a sovereign constitution. The suggestion from the other side is that under 370 sub-article 3, they could have severed their ties with India at the time of dissolution of the Constituent Assembly. My lords, I submit that is an absolute impossibility as far as the Indian Constitution is concerned, because Article 1 would have applied to them irrespective of the nature of Article 370.
Which is the page of your written submission? In the
That's page 2.
No, in the volume 3.
My lords, that is not there in volume 3.
I cut those.
My lords, if my lords allow, please.
All right, thank you.
Please, my lords. Just one more aspect, my lords.
Yes.
If the J&K Constituent Assembly had no original constituent powers, it automatically exercised only derivative constituent powers. If it is exercising derivative constituent powers, it is akin to a legislative assembly. My lords, one of the letters that was highlighted by Mr. Shankar Narayan was a letter by Rajendra Prasad to Mr. Nehru. My lords may remember 1952, 6th of September, I think, 1952 by Rajendra Prasad. That letter finds mention in Mr. Noorani's book at volume 20, page PDF 222, I believe. Mr. Noorani has done a lot of research. He should have also pulled out the letter which was written by the then Prime Minister, Mr. Nehru, in reply to the letter of Rajendra Prasad. Mr. Nehru wrote a letter dated 7/11/1952 to Mr. Rajendra Prasad on a host of issues, after Mr. Rajendra Prasad had also written a letter to the then Home Minister K.M. Munshi. And he highlighted the fact that how this issue has been discussed with the law officers of the union at the highest level with Mr. Gopalaswamy Iyengar and with other people. I have annexed it to my note, my lords. And therefore requested the president, requested being the word, requested the president to consider passing the CO. That was on 7th of November 1952. Within 8 days, my lords, the learned president passed the CO 44, which was 15/11/1952 under 373, thereby changing Maharaja to Sadar area. Therefore, my lords, I think the SG had also pointed it out that actions speak louder than words. That is all that I have.
Yes, Mr. Vikram.
My lords, I'll just make a small submission. My lords, everything is, my lords, my submission is this. My lords have seen the original constitution. The original constitution.
Biju, move towards the center.
Yes. My lords, the original constitution, there were transitional and temporary provisions. It wasn't, the special provision was subsequently added as an amendment at a later point of time. So the original constitution in this chapter was as to temporary and transitional provisions. So the very fact that this is taken to be a transitional and temporary provision means that this is the entire objective of the original part. Subsequently, a large part of it, my lords will recall, has from 75 to 91 have now been amended out. So the original intention of including 370 in that chapter, and it was in the genus of that, was this was a transitional provision. And my lords will see 391 and 392, there were presidential powers which were given to make amendment.
Thank you, Mr. Banerjee.
My only submission is this was permissible to
This has been
follow.
already argued, Mr. Banerjee.
Thank you, Mr. Banerjee. Now, Ms. Pathak, come along, come forward. 1 second, we'll call out. We are calling out people. Don't jump the gun. Yes.
1 minute, my lord.
1 second, Biju.
Yes, I'm sorry.
Yes, Ms. Dave, what do you want to?
I'm appearing in an IA 171722 of 2019.
So what's the point, tell us?
Well, the point that I'm making is, well, the permanent residentship, well, no one has talked about the rights of the women that were taken away. So the permanent residentship would not come to the women who have married outside the state of Jammu and Kashmir. So, my lords,
That was set aside. That was ultimately constitutionally.
yes,
set
my lords, state of J&K versus, my lords, Dr. Sushila Sahani 2002 judgment. In fact, the full bench of the Jammu Kashmir High Court held that they will have permanent residentship even if they marry outside. But the state then, my lords, the learned AG there made a statement that they will not get, in fact, my lords, the right to employment, right to scholarship, as well as the right to hold immovable property was taken away if you marry to a person who is outside the state of Jammu and Kashmir.
Thank you.
Well,
Mr.
it's my written
Biju?
submissions.
Yes, we'll take.
I have.
What is your page of the written submissions?
I'll give it to the learned court master, my lords. We had submitted to the nodal council.
All right.
2 pages only, my lord.
Volume 3, right?
Yes, my lords. There's one
Yes,
question,
Biju.
my lords. We have got these rights now after 2019. Can a writ petition filed under 32 take away fundamental rights given to the other citizens of the country, my lords? Is my respectful submission. I'm obliged, my lords.
Yes, Biju.
I am appearing for my client who is a retired major. He dedicated his substantial time in the area in question, which is J&K. And my lords, my IAS 171000 of 2019 petition civil number 1082 of 2019, my lords. Kindly note this because my.
Biju, just make a point now.
Yes, my lords. 171000 of 2019 in WPC number.
We'll see that. You just make what.
Just what's the substance?
Yes,
What's the point and substance?
My point is this, my lords. Before that, my lord, page 5152 525 of volume 3, my written submissions, where I substantiate what are the ground realities, where I substantiate what was happening, as my lords already asked. My lords, what is after going again and again, 370 sub-article 3 provides so there is a special provision. And if it is non-functioning, then what is the way out?
This point has been argued.
What is it?
Come on now, tell us something.
What is the next remedy, my lords? My respectful submission, my lords, is extremely clear in the Constitution of India, Article 368(1). Then 2 is saying that, 368(2) says that if so and so articles or chapters, if you are going to touch, or if you are going to touch basic structural principle, then you have to have the ratification of the 50% of state governments. In that subclause 2, there is nothing to do with 370. So 368(1) is starting itself is, my lord, extremely important, that language, that notwithstanding anything contained in.
All right, thank you.
Notwithstanding
Thank you, Biju, we got the point. We got the point. Thank you. Sir, there at the back. Biju, there's somebody at the back from Srinagar, Jammu, who is.
This is one area, my lords. Then my respectful submission, my lords, what I did. Again and again, my lords, I was repeatedly reading my lord judgments from 1950 onwards, at least 5 judgments, which are constitutional judgments, saying that there is every power for Indian Parliament and the President of India.
Thank you.
That time, my lord, separately indicated in paragraph.
We'll see on that. Yes. What is your point?
I'm grateful just for the time. Lords, I'm appearing in 108-743 of 2018, Lords. There's an IA filed, Lords, by the Bar Association, High Court of J&K and Jammu. Now, Lords, I adopt, Lord, the submissions of the SG and everybody, Lord, who is supporting this, Lord, CEO. One submission, Lord, if the Honorable Court would permit me, is that whether, Lord, at this 76th year of our association with a country, a question mark, my lord, on our nationality also would not hit, my lord, in the extended interpretation of Article 21. If I would seek the Honorable Court's indulgence, my lord, that whether right to live with dignity, my lord, starting from Menaka Gandhi's 78, would also include, my lord, a right to have a nationality after having lived with the country and identified oneself with. So, my lord, we take pride in being Indians outside of India. But when it comes, my lord, within India, can there be somebody, my lord, allowed to raise a question mark on our nationality? Because, my lord, when I was, my lord, following this, my lord, debate on the VC from J&K, questions like referendum also, my lord, were addressed. Now, in this, my lord, 75th Golden Jubilee, which we say, if, my lord, at this point in time also, a question mark on our identity with a particular nation where we have contributed and will live with pride within India, if this is still, my lord, is hanging in balance, though, my lord, we owe our, my lord, gratitude to the Constitution that this debate is still permissible. But then, whether the Constitution, my lord, can be so flexible as to include a debate also as to a person who has contributed a lifetime. No, this is the third generation, my lord, into it. Now, from 47 onwards, we are now, my lord, in 2023. And in 2023, my lord, if I have to prove to somebody that I am an Indian, whether, my lord, my life is actually a life of dignity, is, my lord, my humble submission. I'll seek honorable bench, my lord, indulgence.
Thank you very much.
I'm grateful.
Thank you.
Lords, 35A is linked to Section 6 of the Constitution of Jammu and Kashmir and is linked to 370. If 272 and 273 is not upheld, what the consequence is that there is a tap on the application of the Constitution of India, including Part 3, which can be turned on, turned off at the discretion of the state government, which by itself is inherently discriminatory, abusive. Yes, which has been therefore, apart from IR Coelho, I think most important is Puttaswamy, where your lordships have upheld the socio-economic interpretation, because for a long time fundamental rights were essentially social in nature, but an economic angle has been brought about. Our problem is we are being deprived of that. One very brief point, my lords, the consistent position of Republic of India, and I deliberately say Republic of India, before the United Nations Security Council is that there was no sovereignty of any kind, slightest nature, residing with the state of Jammu and Kashmir, neither under international law, nor under comparative constitutional law. For comparative constitutional law, there's an opinion of Dr. Ambedkar, which is in my submission, where he said why there is not even an iota of sovereignty with any princely state, including state of Jammu and Kashmir. In international law literature, it is very clear, settled position of customary international law, which was also taken by the Republic of India in the Security Council in MC Chagla's speech, and also Krishna Menon's speech, very clearly spelled out that under international law, there's no possibility of any such constituent, which is an integral part of India, to have any sovereign right. So that is clear. So therefore, no question of Constituent Assembly or Maharaja having any sort of sovereign power. In fact, it was made expressly clear in the Security Council itself by both of them that aspect rests entirely with the Union. So what is being now called as residual sovereignty can't conceptually exist. It contradicts the very idea of sovereignty propounded by Bentham, or even by Max Huber. Therefore, sovereignty, there is only one sovereign. All that they can have is legislative competence, that is also to minimal extent. Apart from that, there was a major argument which was made that instrument of accession had to be approved by JK Constituent Assembly. It wasn't necessary. The only requirement was Section 6 of the Government of India Act. This was the consistent position again put forward by MC Chagla before the United Nations Security Council. Also under section, one very last point, India was the successor state which included princely states. That comes from section 311 of the Government of India Act. Therefore, by virtue of that, India already a singular entity where all sovereign authority rests with the Union and the constituents don't have any other power. To use the phrase of Krishna Menon, they're sub-sovereign entities.
Yes.
Advocate General, and nothing for UT. Yeah.
United Nations. This is past history. There is nothing pending in United Nations or any. It is our internal.
Yes, my lords. Only thing I was saying, that's the position, that there's no such internal.
being the AG, first of all, I subscribe to the submissions made by attorney and solicitor general and my colleagues on this side. One aspect, perhaps need to be brought, but the basic fundamental rights include the health also. And health generates from the health medical education. All judgments, whenever it would come, I'm passing a judgment to Lordship just now. But kindly see the plight in J&K. Whenever it comes to the taking a health care, the point would be that we, because of 370, will not allow for those benefits which are emanate from Article 21 to flow to J&K. Now I'm passing to judgment of this Honorable Court. But whenever this issue comes, this is 1984, where they say, yes, for the rest of the country, that she's sending 70% of seats and 30 for local, it's funded. But when it comes to J&K, even this Honorable Court says, we'll wait till the time comes. How long will this medical facilities, which are, just have a look to these judgments. Right? In this last paragraph, the court says, so far as J&K and Andhras are concerned, we are told that there are some constitutional provisions, and therefore we deal. The result was that for so many years, the erstwhile state of Jammu and Kashmir and now UT remained deprived of the basic fundamental rights, including the medical education. So let's just have a look to this.
We'll have a look at. Thank you, Mr. Advocate General. Thank you.
There's a short
All right,
holding my.
everyone 1 minute each. Yes.
Yes, my lord. Just before I conclude, all speeches, because I know that time, all exercise, understanding and the literature. One word is very important. All leaders, including Mr. Sheikh Abdullah, in unequivocal terms said accession, not the aggression. In the parliament on 8 January 48, everywhere. No blood, even at this stage of 75 years, yet we have to define our relationship with it. But as Article 371, Part D, Part 3, they were discussed so. In all cases, we are the integral part of this great nation, Union of India. All arguments to the contrary are too late in the day when the Constitution of India had all its place, and now it is only academic, otherwise we are a part of that. I'm grateful.
Thank you, Mr.
Lord, the short submission. This amendment A cannot be seen as a silo in light of the larger transformative nature of a constitution. 3 bullet points that come in it. The violation of rights of those who are persecuted is so extensive, my lords, that it has been recognized as a grave human right violation in 2019. A violation, my lords, which is considered an international crime in international law, therefore attracts customary international law and is jus cogens norm. So therefore, my lords, when such an acknowledgement does come in, really a case for restorative and transitional justice does arise. So clearly, my lords, those who have been persecuted and they want to go home, it will have to happen that security is ascertained and restorative and transitional justice does arise. So fact-finding missions, truth commissions, transitional commissions, therefore become the norm. Unless and until, my lords, an amendment of this nature does not come in, that takes away the conditions of oppressions that were there and that ensured that they were not only persecuted but had an exodus in 89 and 90 is not taken away. This higher feature cannot really be attained, my lords. So therefore, my lords, I submit that this has to be seen holistically and attributing of responsibility.
You can put it in your note. It's in your note.
Now, I'll limit my intervention on just 2 aspects, Lords. One is the proviso under Article 3, my lords. The contention of the other side was that the requirement of taking the views of the state legislature is a condition precedent. My lords, as the learned Solicitor General has shown already that wherever Article 356 was invoked, this proviso to Article 3 was suspended. Secondly, my lords, the views of the state legislature under the proviso are not binding on the parliament. Your lordships have so held in Babulal Parate's case. Thirdly, my lords, Article 3 is a plenary power. So any interpretation, any construction cannot be given to the requirements of obtaining the views of the state legislature, which denudes from this plenary power. My lords, the second argument is the Rajagopal case, Karunanidhi's case, which was cited by the petitioners, is wholly inapplicable, my lords. That is a 1-paragraph judgment, and the finding that is given in that judgment is that dissolution of state assembly will not be a ground to hold that the constitutional machinery has been broken down in the state. Rajagopal case relies on UNR Rao, which is delivered by the same bench of your lordships. In UNR Rao, the contention was that a writ of quo warranto was sought against the Prime Minister and her cabinet. The contention was that since the House of People has been dissolved, and since the cabinet is responsible to the House of People under Article 75(3), the president should dismiss the cabinet. Your lordships rejected this contention and said that Article 75(3) will only apply where the House is not dissolved or prorogued. So this case is wholly inapplicable.
Thank
My lords,
you.
my note is
My
on
lords.
volume 6, PDF page 50. Kindly consider that. I'm grateful.
My lords, my IA is, my lords, 146764, my lords.
Yes, Mr. Bhushan, what do you have to say?
Yes, my lords, I have to say, or make only one summation that this temporariness and permanentness of Article 370 has to be looked through the prism of word further in the preamble of Jammu and Kashmir, read with Section 3 and 147 of Constitution of Jammu and Kashmir also. Even Constitution of Jammu and Kashmir has not given power to itself to amend Section 3, where it is said that it is and shall be the integral part of Jammu and Kashmir Constitution of India. And second is will of people. This was argued strenuously.
Lordship, I appear.
Yes,
for,
Dr. Khanna.
Lordship, I appear for Youth for Kashmir, Pannu Kashmir. We were the people who were displaced in 1990s, whom I represent. Lordship, my first point of submission is when the instrument of accession was signed, that day it was complete and formal integration with India. And
That point has been made. What is the next point?
Lordship, the second point that I wanted to make, that because of 370, there was no economic integration with India. That was we were making. And the other point I wanted to make was regarding the women's right, which Ms. Pathak has made. And Lordship, the final point I want to make it till 2016, even transfer petitions could not be filed in this court under the regular provisions. We have to approach under 32 or in the other provisions.
Thank you. Yes, yes, sir. What do you have to say?
19618, my lord. In my matter, my lord, no counter, no students has been filed, my lord. I got a letter circulated on 27th July, my lord, saying therein that I shall be able to file for written submission only after hearing both the parties. Now I am kindly be allowed to.
What? And what is that SLP?
118, my lord.
Filed by whom?
Filed by whom actually? You are the SLP petitioner.
My lord.
What is the order that you are challenging?
My lord, I am challenging the order passed by the High Court, my lord. I sought there, my lord, to declare Article 370 a left provision. Second, my lord, declare separate constitution for the J&K void ab initio.
That is
My lord, that I am seeking permission. I am seeking permission to file written submission in view of my letter, my lord, which I circulated on 27th July.
So we'll come back after.
Yeah, why, during recess, may I just
going
file
through my
my submission so that they are on record?
My lord, after going through my written submission, my
They are
lord,
longer
Because
than
I have
the
to
main
reply, Malad, I have to reply. Put
They
it
are
down.
longer than the main arguments.
I'm sorry?
You can open your submission.
My lord,
We'll see.
permission.
That's what I'm saying, Malad, that I will.
We'll hear you, Mr. Sibil. After lunch, we'll hear you.
In the meantime, I should be able to file, Malad.
They are longer than the main submission.
One second, you have filed hundreds of documents. I never objected. Even my first submission, you never. What is all this?
At lunch. We'll
My
hear
lord,
you at lunch.
written submission may can be permitted to
Well,
file,
if
my
you-
lord.